Welcome to Illinois Law, sponsored by the Illinois State Bar Association. I'm Sam Kavathas, and I'll be your host tonight. Tonight's topic is medical negligence and the law. I have three fine guests to help us with tonight's topic. My first guest is Judge Elizabeth Budzinski. She is a judge in the Circuit Court of Cook County for the past 9 years. She presides currently over jury trials in the Law Division of the Circuit Court of Cook County. Prior to her current assignment, she presided over the motion call in the Law Division. She also presided over the Domestic Relations Division and Traffic Court. Judge Budzinski regularly conducts seminars on various civil topics. She is a past president of the Women's Bar Association. She is also currently on the Illinois State Bar Association Tort Committee. Judge Budzinski regularly conducts seminars on various pretrial and trial issues. She is head of the Judicial Education Program on Civil Issues. Welcome, Judge Budzinski. My second guest is Karen McNulty Enright. She is the founding partner of Winters, Enright, Salzetta, and O'Brien, LLC. Ms. Enright focuses on catastrophic personal injury and medical malpractice cases. She is currently on the Board of Governors of the Illinois State Bar Association and has recently been elected the Treasurer of the Illinois State Bar Association. Ms. Enright is past president of the Women's Bar Association of Illinois. She has tried and settled multiple cases and has achieved multiple million-dollar verdicts in the area of personal injury and medical malpractice. She has recently been rated by the Chicago Magazine as one of the top 50 women lawyers in the state of Illinois and top 100 lawyers in the state. She has been recognized as a super lawyer and has received various awards for public and community services. Karen, welcome to tonight's show.
Thanks, Sam.
And my third guest is Ron Kalish. He has been a trial lawyer since 1992. He is a partner with the firm of Steinberg, Goodman, and Kalish, where he concentrates his practice on personal injury, medical malpractice, and product liability. Mr. Kalish has tried numerous cases to verdict in the areas of medical negligence, nursing home, neglect, motor vehicle crashes, premises liability, and cases against municipalities and common carriers. He has argued before the Illinois Appellate Court, the Illinois Court of Claims, and he is admitted to practice before the United States Supreme Court. Ron is AV rated by Martindale-Hubbell. Ron volunteers his time teaching constitutional law to 7th and 8th graders in the Chicago public school system through a program called Lawyers in the Classroom, coordinated by the Constitutional Rights Foundation. Ron, welcome to tonight's show.
Thanks for having me.
Now, tonight's topic is medical negligence in law, and I've heard about the cases. How does that different from your typical automobile, motor vehicle, premise liability cases? What's different about a medical malpractice case?
Well, I think one of the most important differences is a malpractice case. In order to even have a lawsuit filed here in Illinois, you have to have the records reviewed by an expert in the field of the medicine at issue. And that's much different than a typical injury case where you don't need that initial review.
Is that before you get started with the case or before you file a lawsuit? What was exactly when you say it has to be reviewed?
That's before a lawsuit can be filed, and typically before a lawyer will agree to accept your case. And that is designed to make sure that there aren't frivolous or unnecessary lawsuits brought against doctors and hospital and other medical care providers.
And when you say reviewed, who reviews it, and what do they have to give you, or what do you have to get before you can file a lawsuit?
There has to be a physician that specializes in the same type of medicine that you have your complaint about. So if you think that there was a failure to diagnose cancer, you would need an oncologist to sign an affidavit saying that there was that failure. Or if you had a knee surgery that went bad, you would need some type of orthopedic surgeon to say that there was a deviation from the standard of care in which that surgery was done, which is a lot different. Medical cases are a lot different than, say, automobile cases. If someone ran a red light and hit you, you could file suit against them, and it's your word against their word, or a police report. But in a medical malpractice case, in an effort to, as Ron said, make sure that the cases are not frivolous, we have this standard whereby the physician needs to file and sign that affidavit.
Now, who pays for that?
Well, typically, it can go either way. In certain cases, we will ask the prospective client to put that money up front That's a fee that goes to the reviewing physician. Or on some occasions, some lawyers might take a risk and put out the money themselves. But ultimately, you need to have that doctor sign that affidavit before you can get your foot in the door.
And Judge, what happens if a case is filed and they don't have one of those affidavits?
Well, several different circumstances could arise. One is that they haven't been able to obtain all the medical records, and therefore the judge can give them an extension to obtain the medical records, have an expert review them, and obtain the affidavit. That would be the typical situation. If they cannot get an expert to state that there is a cause of action, that there's a breach of the standard of care that caused the injuries, then the case would be dismissed. They can't go to court with that case.
So the court would actually rule on that and look at the affidavit and
Yes.
see whether or not it's adequate for actually filing a suit before you even get to a lawsuit.
Yes.
So the lawyer wants to make sure before they put the money into filing the suit, most of the time they have to have that affidavit before they even go ahead and file it. And a lot of times when you're the subject of a malpractice case, you can't work, you're injured, and so the lawyer most often puts up the fee to have the case reviewed.
So you hear about, people can just run to courtroom and file a lawsuit, like you were talking about, but in the medical malpractice cases, they have these certain safeguards, per se, to protect from that happening.
Right, and that's decreased the amount of cases that have been filed over the past 5 years alone. There has been such a decrease in the amount of cases because every case that has been filed essentially needs an affidavit from an expert in that field, and it's getting tougher and tougher because insurance companies don't want physicians necessarily signing off on lawsuits, even though there are a lot of injured people.
Well, taking it, for example, someone would say, well, you can just go get any doctor to go file a lawsuit for you. As an attorney who handled medical malpractice cases, are you just going to go out and find somebody so you can file a lawsuit? And if not, why not?
Well, that's a dangerous practice to get into because ultimately we have to prove our case to a jury and convince them that that there was a deviation from the standard of care. And just to have any old doctor put their name on something, I suppose someone could find that kind of doctor, but the system has a built-in protection because we don't want to have that case where we're not pretty certain that there was a mistake made. We want the doctor to make sure that they've told us all the issues that there are.
And medical malpractice cases can cost the attorney upwards of $100,000. So in order to make that investment, you want to make sure you have the best expert backing you. So from day one, you normally go to the top experts in the field to determine whether or not there has been malpractice. You're the one fronting the cost, you're the one taking the risk, and you're doing it on behalf of your client. So you want to make sure that you have the best, because you're always going to be prepared to go to trial. You want to make sure you have your best game going.
So what happens if you lose that case and you spend $100,000?
You eat that. The
So
client
that's
doesn't
why
pay for it.
that's why lawyers who handle malpractice cases for injured people aren't just running out filing lawsuits unless they're pretty confident and have a competent doctor who told you that it's a good case.
You run the risk of having to try that case to a not guilty and having put in a substantial amount of time and money and commitment to it. So.
And I imagine the lawyers on the other side for the hospitals, our doctors, are pretty good lawyers too.
Yes, I think you see some of the top lawyers working on these kind of cases because they're very sophisticated, they're complex, and which it's not always reported in the papers, but there's a lot of not guilties against the doctors. And they're tough cases.
Do you see, Judge, a lot less cases in the last few years of filing these medical malpractice cases?
I think there has been a decrease, and I think part of it is the requirement of the affidavit ahead of time and the cost involved in the case. As Ron and Karen have stated, it's a lot of time, effort, and money to invest, especially when I think the verdicts are 80 to 90% are in favor of the doctor. So you really need to know what you're doing and have the good experts and be ready to try their case.
For the person who thinks they have a malpractice case, one, how do they find a lawyer who does medical malpractice? And two, what are you looking for in a medical malpractice lawyer?
I think the thing that they need to most look for is someone that has tried and settled medical malpractice cases in the past. A lot of times you'll find a general practitioner, and it's kind of just like when you're looking for a doctor. You're not going to go to an orthopedic surgeon if you need your wisdom teeth pulled. You want to make sure you're going to someone that specializes in that. And I think in law, you know, we have certain areas, real estate, you have wills, you have trust, you have personal injury, but even more specialized, you have people that practice in medical malpractice. So you can research and you can look on their websites and you can do searches on the internet as to how many cases they've tried and they've won in the area of medical malpractice. You want to make sure that you have someone that is specialized. And when you interview them, you can ask them, how many cases like this have you had? How many cases have you personally tried? And I think you'll find a discrepancy in different lawyers that you talk to.
Yeah, an important question is not only how many have you had and handled, because the truth is good cases should settle, but more importantly, how many have you actually tried to a verdict? Because that's a distinction amongst many lawyers. You know, it's one thing to take a case, and if it's, as I said, a strong case, it should settle, but you need to know that your lawyer can take the case from start to finish.
Now, you hear about medical malpractice. Can you just sue the doctor? Who else can be sued in medical malpractice cases?
The hospitals can be sued, the nurses can be sued, there's suits against chiropractors, and you know, they're expanding.
So there's other things. I mean, how about a dentist?
Oh yes, of course, a dentist.
I mean, anybody in the medical field, optometrists, podiatrists, are those all cases where you can sue somebody?
Yes.
And can you just go get that a doctor who just looks at the records, or is there anything special you got to have for these affidavits you're talking about?
Well, when you walk into, say, a hospital, you go into an emergency room and you have some type of emergent medical situation. Sometimes you'll be seen by an attending, sometimes you'll be seen by a resident, sometimes you'll be seen by a nurse. Some people are employed by the hospital, sometimes they're independent contractors. So for each different specialty of whoever saw you, you need to have an expert in that field. So if one person was infectious disease, but the next person was trauma, you want to make sure that the case is reviewed by someone in infectious disease and trauma in order to make sure that something went wrong. If there's a chiropractic case or a nursing case, you want to make sure that there's a nurse who's reviewed it or a chiropractor that's reviewed it.
So you can get really complicated if you go into an emergency room, you're seen by a number of doctors, and then you're admitted to the hospital, and then something happens to you in the hospital. How do you find out who's all the people that are involved in this?
Well, what we generally do is we start very broadly, and we include anybody who may have caused or contributed to the injury. There can be more than one doctor or medical care provider at fault or that has caused the injury. It doesn't have to be, there isn't just one person involved. It's often a chain of events, and all of those people can be held liable.
We're going to get back to that in just a minute. We're going to take a short break. This is the Illinois State Bar Association, Illinois Law, and I'm Sam Kavathas. We're talking about medical negligence in the law, and we'll be right back with our guests.
Bye, Tyler.
Dear, it's time for serious talk.
Oh?
About my daycare. When I started out, it was just to help the neighbors. But lately, it's getting to be a real handful. I need some help.
What can I do?
I need advice on more space, a loan,
What about incorporating?
and insurance.
Wait, I know who we can call.
Times like this require sound advice. Your lawyer can help. A message from the Illinois State Bar Association. Over and over. Time and again.
Drive me nuts. Shut up. You're the dumbest.
Generation after generation.
I hate you. I hate you too.
Isn't it time we stop the cycle? Now.
I hate you. I hate you.
Stop adult violence. Teach kids peace. A message from the Illinois State Bar Association.
Welcome back to Illinois Law, sponsored by the Illinois State Bar Association. I'm Sam Kavathas, your host for tonight's show, and we're talking about medical negligence in the law. My guests tonight are the Honorable Judge Elizabeth Budzinski, Karen Enright McNulty, Enright, and Ron Kalish. We were talking about who you're going to sue and how you go through all that process, Ron, and you were finishing up on going over how you decide who you're going to sue. Once you decide this and you get your affidavit, what do you do next?
Well, the next is filing that lawsuit. You're assigned to a judge in the courthouse, and the discovery process begins. And that's an opportunity for each side to exchange written questions between each other, exchange documents between each other, and ultimately give a deposition, which is a time where really each of the parties gives their version of what they say occurred in front of a court reporter.
And how long does a case like a malpractice case, and maybe not such a complicated one, but typically how long does a malpractice take from the time you file suit until you either try it or get settled?
Because of the complexity of medical cases, they tend to take longer than your average cases, but it could be anywhere from 3 to 5 years. I would say average is about 5 years.
So if a person has a case going on, they're saying, what's going on with my medical negligence case? Is it necessarily the lawyer's dragging his feet or not doing much, or what's the reason why?
The discovery process is so long because usually in a medical malpractice case there's so many different doctors or treaters that are involved. I mean, usually something happens in one setting, but the person continues to have care and treatment in another facility with different doctors. So all of those records need to be obtained, and then everyone needs to be deposed as to what the injury was and what the damages are and what the future will hold for that patient.
How does a medical negligence case differ from another case as far as proving somebody's at fault?
Well, you need an expert. That's the biggest difference.
And when you say an expert, what does that mean?
Well, an expert is somebody who is qualified by experience, by education, by training, to review all of the records and depositions in the case and come to court and testify that a doctor or a medical care provider, what's called deviated from the standard of care, and that's really a fancy word for saying that somebody didn't act like a reasonably careful doctor would have acted under those circumstances.
And how many experts are there? Does everybody need an expert? Or
Well,
does everybody
typically
get
in medical
one?
malpractice cases, every party has an expert, and you might need more than one often in a case, depending on what the issues are.
And then if it doesn't settle, then what happens to the case?
Then you go to trial, and that's where the expensive part comes in, because each side needs an expert, and anyone who's treated that person past that time has to come in as well. So you might have had surgery on one organ of your body or one part of your anatomy, and say there was a failure to diagnose an infection after that surgery. Sometimes the surgeon's involved, sometimes everyone who saw that person for the next 5 or 10 days post-operatively, they might be involved. So they all have to come to trial and talk about why they didn't pick up on the infection. And then you need your experts to come in as well. So that is what takes the time and the money in a malpractice case, because as the judge has said, they can be very complex situations.
Is there cases where, people say, well, I was injured by a doctor. I mean, just because you're injured or something happens in the treatment, does that necessarily mean you have a malpractice case?
No. I think an important point is not only do you have to have the experts say that you deviated or breached the standard of care, but that breach or deviation of the standard of care approximately caused the plaintiff's injuries. So it's a two-step.
One of the hardest things when we get calls in our office is we'll look at a case and we will see clearly that a doctor made a mistake. But oftentimes that mistake either doesn't result in serious harm or injury, or the mistake can be fixed rather quickly and doesn't result in the kind of injury that not that the law doesn't require it, but in practical setting, we can't take that kind of a case.
So somebody may have been injured, there may have been some negligence, but because it wasn't significant enough or the person's made a nice recovery, you just don't pursue those kind of cases?
Most experts won't sign off on that. An expert who's an expert in the field will say as long as there is a deviation that something definitely went wrong and that there is a substantial damage that occurred as a result. We have a lot of times, unfortunately, where there are misdiagnoses of cancer, but if the misdiagnosis was 3 or 4 or 5 months and the physician says it did not cause or contribute to any of the damage, then unfortunately there isn't a case. You need an expert to say not only was there a misdiagnosis, but this significantly impacted this patient's treatment.
How about if a doctor decided to do a procedure one way and it didn't work, and there may have been another procedure? I mean, is that necessarily malpractice? He decides his judgment of what he thought was?
There are lots of instances where a doctor does the procedure or surgery the right way, and there's a bad outcome. There's a certain percentage of medical procedures that just I wouldn't say don't work, but have a rate that you're just not successful.
You always hear the doctors always tell you, this is a risk of this, there's a risk of that. I mean, just because they tell you that there's a risk of this and that occurs, or you sign releases, does a release necessarily make the doctors not liable anymore?
I think you see a lot of infection cases where it's usually the first word in every release form that you sign, risk of infection. Anytime they make an incision or any opening in your skin, there is a risk of infection, even when it's done under the most sterile conditions.
You hear that at hospitals all the time, the infection. Is that necessarily a reason that you can sue a doctor for that?
It can be, but most of the time, because infection is always a risk of almost every procedure, they're usually not cases.
But if you take an obstetric case, a lot of times a physician would say, well, I would have delivered this baby earlier. I would have delivered this baby using a different maneuver. It doesn't necessarily mean there was malpractice because they would have delivered the baby differently. But if, let's say there was a C-section and there were known risks to the C-section, and known risks might include infection or might include bleeding, but that doesn't necessarily mean, the bladder can be cut or something else. So there might be known risks, but there are also things that can happen that are not known risks that the physician is still responsible for.
So just because, like you said, though, something bad happens in any medical care or treatment doesn't necessarily mean that you got a medical malpractice case.
That's right, probably more often than not.
Okay, how about the difference in, you hear people going to nursing homes and people get injured in nursing homes or something happens in a nursing home. Is a nursing home case a medical malpractice case?
Well, it not necessarily. It depends what the injury is. Typically, nursing home injuries are falls. Someone's not being properly taken care of. They're not being looked after. So you don't need a 622 affidavit, which we were talking about. We don't need an expert to say that the nursing home caused harm unless it's a medical diagnosis or treatment that caused harm to them. But typically, they're just taking care of people in the nursing home, and it's about proper care.
Right. They're not providing medical care per se, but they're
neglected them or something like that.
There's a statute in Illinois, the Nursing Home Act, and the words abuse and neglect appear in there, and it's a very broad definition of when you can have a case involving nursing neglect.
So in those type of cases where there is abuse and neglect and it's not necessarily treatment, you don't necessarily need to have somebody who's a medical malpractice lawyer handle that kind of a case?
Well, I think a lot of the issues involve medical injury, whether it's a development of a pressure ulcer, a decubitus ulcer, whether it's dehydration, malnutrition. Those are typical kinds of injuries that you see, or a fall that you see, and they involve medical issues. So I think the prudent course would be to find a lawyer that has handled medical malpractice cases. There's a little bit of an overlap, I think.
How about as far as when you handle these cases, how is a lawyer, or who pays the lawyer in these kind of cases? Let's start with the medical malpractice case. Who pays the lawyer and who determines the fees in the medical malpractice case?
The lawyer is paid on a contingency fee basis.
What does that mean?
That they get a percentage of the overall settlement or the verdict. And in Illinois, it's capped. There's only a certain percentage. Normally, we'd start off in an automobile case, say, getting a third. But in medical malpractice cases, it's capped and it's structured pursuant to what you receive. So the more you receive, the less the lawyer gets.
And why is that?
Because there was a huge lobby by by the Medical Association to cap lawyers' fees in these types of cases in hopes that lawyers wouldn't pursue medical malpractice cases on behalf of injured clients. And
So what is the cap? How does it work?
It's a third, 33.33% of the first $150,000, and then the next $850,000 is the fee drops to 25%, and anything over $1 million, the fee drops to 20%. And there is a provision in there that allows a lawyer to ask a judge to award additional fees if the case involves complex issues, and that's something that the court ultimately has to decide whether that lawyer is entitled to a typical
And
one-third
how
fee.
does it happen, Judge, the lawyer, you determine that they might be entitled to additional fees? Is it just they petition it?
It's a petition, and lawyers will present affidavits on what they did and why it is above and beyond your typical medical malpractice case. And typically in these cases, what I like to see is an affidavit from the client agreeing that the lawyer is, you know, deserving of that. If they've agreed that the lawyer will take, you know, will give them extra money.
But on the flip side, if you don't win these cases, you are not paid.
So the client doesn't have to pay any fees or money, anything to the lawyer if the lawyer doesn't win?
Right.
And how about we have like about a minute, 30 seconds left. And that, just nursing home, is that any different as far as the fees are concerned with
Yeah,
that?
the Nursing Home Act that I mentioned earlier has a fee provision in it, and that's important because people in nursing facilities are the elderly and the sick, and sometimes those injuries aren't significant enough, and the purpose of having a fee statute, which means if you win, the nursing facility has to pay the attorney's fees for you. That's done to really encourage lawyers to look at these cases when they involve small injuries.
All right, listen, we're just about done with time. Thanks very much to Judge Budzinski, Karen Enright, McNulty, and Ron Kalish for being our guest tonight on Illinois law, sponsored by the Illinois State Bar Association, on medical negligence in the law. Thank you very much for being our guest tonight.